quickly. Sound bites replace standards, opinions replace facts, and legal conclusions are often announced before the law is even explained. Cannot help, but only hurt, causing sometimes an escalation in the events that inflame emotions and passions on both sides that can contribute to dangerous situations. Welcome, and thank you for being here for the first episode of the first season of the Teske Brief. Before we begin, and before I forget, I want to invite you to subscribe below. If you do, you'll receive notices of upcoming episodes of the Teske Brief, including special myth versus law segments when important legal or policy issues break in real time. My name is Steven Teske. I'm a lawyer. Specifically, I'm a trial attorney and was a partner in an Atlanta-based law firm before my appointment to the bench, where I served for more than 2 decades before returning to the practice of law. As a trial attorney, I did civil and criminal litigation, which included serving as a special assistant attorney general for the state of Georgia, representing state employees sued by citizens alleging violation of civil rights and State Tort Claims Act, like negligence, including wrongful death. In this capacity, I also prosecuted child abuse and neglect cases. As a judge, I presided in juvenile court involving juvenile delinquency and child neglect and abuse, as well as in superior court presiding over adult civil and criminal cases. I guess if you want a label, you could call me a utility judge. I handled a little bit of everything. Since this is the opening episode of this podcast, and before I dive into the substance and content of this first episode, I think it is important as the host to share a few things about me that will help listeners understand what makes me qualified to talk about the law and public policy. And this is the last you'll ever hear about this. I'm a former law enforcement officer, about 10 years, and have made many arrests during my tenure, and I left that role to practice law. And during my judicial tenure, I published extensively, both scholarly and professional journals. I contributed a chapter to a recently published book called Restorative Justice in Legal Systems, Education in the Community. And I've also authored a book titled Reform Juvenile Justice Now. I've been called 4 times to testify before Congress as an expert, and I've also testified before several state legislatures. My expertise is in the area of juvenile and adult criminal justice reforms. I served as president of the Georgia Council of Juvenile Court Judges, the national chair of the Coalition for Juvenile Justice, and as a board member of the National Council of Juvenile and Family Court Judges. I'm a Henry Toll Fellow with the Council of State Governments, and I was appointed by 3 Georgia governors to numerous boards, councils, and commissions focused on criminal justice reform, child welfare reform, family violence, and judicial policy. I hold a master's degree in political science with a concentration in public policy and administration, and, of course, a Juris Doctor degree. Again, I share all of that to explain why this show exists and why I'm the host of this show. The Teske Brief is about law and policy. More specifically, it's about separating myth from law and myth from policy reality. In moments of public controversy, especially those involving law enforcement, civil rights, and government power, misinformation spreads quickly. Sound bites replace standards, opinions replace facts, and legal conclusions are often announced before the law is even explained. This show exists to slow that down. Each episode of the Teske Brief will focus on identifying common myths, explaining what the law and policy say, and helping you understand how these systems really work, and sometimes where they don't work well at all. In this first season, we will open with a series of myths versus laws surrounding the events taking place in Minneapolis as ICE has moved in to enforce immigration laws. This series is titled Minneapolis Under Siege, Myths versus Laws. This is a good place to start because it is current and, in fact, still happening. And there's been a lot of statements and commentary making assertions about the law and Constitution that are in fact, are myths. They're inaccurate. And the myths, or otherwise called misinformation, cannot help but only hurt, causing sometimes an escalation in the events that inflame emotions and passions on both sides that can contribute to dangerous situations. In this first episode, called Myths, Laws, and Federal Power, I've collected 10 statements that assert what is believed to be a truth that has occurred during these events in Minneapolis, but in fact are incorrect. I'm starting off at like 35,000 feet, as if a plane looking over the vastness of the earth below just before its descent to the ground, where you can see about everywhere. It's kind of general. But as we get closer and closer to the runway, with each episode, we will be digging deeper and deeper into each myth and more myths to explain what the law actually says compared to the myth that was asserted. After this episode, we will start our descent and go deeper, like I said, with every episode, using what is happening in Minneapolis as our teaching tool. So let's begin. Myth versus law number one. Federal agents can't be prosecuted by states. Now let's pause for a moment and separate myth and, the myth from the law. The myth is this: states can't prosecute federal law enforcement officers for crimes committed on duty. Now here's the law. Federal officers are not above state criminal law. Under the Constitution, a federal officer avoids state prosecution only if he or she was acting within lawful federal authority and did no more than was necessary and proper to carry out that duty. And here's how the courts actually apply it. Judges ask whether the officer exceeded his authority or used force beyond what was necessary. If so, state prosecution is legally permissible. So when you hear states have no jurisdiction, understand this. That's not how the Supremacy Clause works. That's not opinion. That's how the law works. Myth versus law number two. Qualified immunity ends the case automatically. Now let's pause for a moment and separate the myth from law. The myth is this: if qualified immunity applies, the case is over. But here's the law. Qualified immunity protects officers only for discretionary acts and only when no clearly established law was violated. And here's how courts actually apply it. If the allegation is that an officer violated a clear policy, a law, or training requirement, a ministerial act, immunity does not end the case. A jury decides the facts. Now, later on in another episode, we're going to talk about ministerial act. We're going to break it down for you. So when you hear qualified immunity means dismissal, understand this: immunity depends on facts, not labels. And that's not opinion. That's how the law works. Myth versus law number three. Failure to comply justifies deadly force. Now let's pause for a moment and separate myth from law. The myth is this: if someone doesn't comply with police commands, deadly force is justified. So let me repeat that. If someone doesn't comply with police commands, deadly force is justified. But here's the law. Deadly force is permitted only when an officer reasonably believes it is necessary to prevent imminent death or serious bodily harm. And here's how the courts actually apply it. Judges and juries evaluate the reasonableness of the force at the moment it was used, not whether the person was compliant. So when you hear she should have complied, understand this. Noncompliance does not forfeit constitutional protections. That's not opinion. That's how the law works. Myth versus law number 4. Body cam footage always tells the whole story. Well, let's pause for a moment and separate myth from law. The myth is this. If body camera footage exists, the legal question is settled. But here's the law. Courts evaluate the totality of the circumstances, including events leading up to the use of force, not just what appears in a single camera angle. And here's how courts actually apply it. Judges consider multiple videos, witness testimony, physical evidence, training, warnings, and timing, not just what one camera captured. So when you hear the body cam proves everything, understand this. Video is evidence, but not a verdict. That's not opinion. That's how the law works. Myth versus law number 5. Federal law enforcement automatically overrides local law. Let's pause again for a moment and separate myth from law. The myth is this. Federal agents automatically outrank state and local law enforcement. Here is the law. Federal authority is limited by statute, jurisdiction, and purpose. Federal agents may act only within the authority Congress has granted them. And here's how courts actually apply it. Judges ask whether the federal action was authorized by law, not whether the officer wore a federal badge. So when you hear federal trumps local, understand this. Jurisdiction is defined by law, not rank. That's not opinion. That's how the law works. Myth versus law number 6. If the officer felt threatened, the shooting was legal. Let's pause for a moment and separate myth from law. Here's the myth. If an officer says they felt threatened, the use of deadly force is justified. Here's the law. The legal standard is not subjective fear. It is whether a reasonable officer in the same situation would have believed deadly force was necessary. And here's how courts actually apply it. Juries examine objective evidence, positioning, distance, movement, timing, and alternatives, not just the officer's stated feeling. So when you hear he feared for his life, understand this. Fear must be reasonable to be lawful. That's not opinion. That's how the law works. Myth versus law number 7. Civil and criminal standards are the same. Let's pause for a moment and separate myth from law. The myth is this. If an officer can't be convicted criminally, they can't be held civilly liable. But here's the law. Criminal cases require proof beyond a reasonable doubt. Civil cases require proof by a preponderance of the evidence. They are different standards. Proof beyond a reasonable doubt is our highest standard in the law, whereas preponderance of the evidence used in civil cases is about 2 steps below beyond a reasonable doubt. It's kind of a halfway plus what my evidence professor taught me in law school. It's 50% plus a peppercorn. You know how small a peppercorn is. But here's how the courts actually apply it. An officer may avoid criminal conviction, but still face civil liability. And think of it, because the standard of proof beyond a reasonable doubt way up here versus preponderance of the evidence in civil cases way below, it can be easier to prove a civil case than it would be a criminal case. So when you hear no charges means no wrongdoing, understand this. Different cases, different standards. That's not opinion. That's how the law works. Myth versus law number 8. Training doesn't matter in use of force cases. Let's pause for a moment and separate myth from law. And here's the myth. Officer training has no legal relevance, but the law says training is critical. When training establishes clear rules, it can create ministerial duties, that thing we're going to talk about later in much more detail, that officers are expected to follow. And here's how courts actually apply it. Juries consider whether the officer followed or violated their training when deciding reasonableness and liability. So when you hear training is just guidance, understand this. Training can define legal duties. And that's not opinion. That's how the law works. Myth versus law number 9. If the government investigates itself, that's enough. Let's pause for a moment and separate myth from law. The myth is a government investigation alone guarantees accountability. The law says investigations must be independent, thorough, and credible. The Constitution does not require blind trust in self-policing. The government cannot police itself. And here's how courts actually apply it. Judges scrutinize conflicts of interest, access to evidence, and whether the process was fair. So when you hear they investigated themselves, understand this. Process matters as much as conclusions. That's not opinion. That's how the law works. And then finally, myth versus law number 10. Accountability is anti-law enforcement. Let's pause for a moment and separate myth from law. The myth is this. Holding officers accountable undermines law enforcement. But the law says accountability strengthens legitimacy, public trust, and constitutional policing. And here's how courts actually apply it. The law protects officers who act reasonably and holds accountable those who don't. So when you hear accountability hurts policing, understand this. Accountability is constitutional policing. That's not opinion. That's how the law works. Again, ladies and gentlemen, these are illustrations. They're not verdicts. In upcoming episodes, we'll take deeper dives into each of these issues, carefully deliberating and grounded in law. One final note. Because law and policy don't operate on a fixed schedule, there may be times when a contemporaneous event requires me to interrupt planned episodes to deliver a timely myth versus law or policy clarification. When that happens, it's because accuracy in real time matters. In the coming episodes, we'll continue exploring the Minneapolis events, not through speculation, but through doctrine, examining immunity, use of force standards, training, accountability, and the constitutional structures that govern these cases. And from time to time, I'm going to bring in experts for an interview to present it from their perspective in the area that they're experts in. If you're looking for outrage, this may not be the show for you. If you're looking for clarity, for law instead of slogans, and for explanation instead of assumption, well, welcome to the Teske Brief. And as always, we'll let the law speak louder than the talking points. In the meantime, everyone, take care and be safe.